There, that's better. And hang on a sec here. And that's better. And hang on a sec here. Was the one flaw in my plan. I need to put my hair up. Hey, welcome to the NAP evening special edition, where we're going to cover part 2 of the Justice Committee, Justice and Human Rights Committee. First off, let me go to just have a quick look here at a recent X post by Andrew Lawton, just to frame before we get into committee. Do this here. And it goes, watch Liberal MPs accidentally did the right thing. They voted for our motion urging mandatory minimums for child abuse because they didn't know what they were voting on. After a suspension, Mark Miller confirmed the motion passed, then ended meeting 2 hours early. Now, this was the meeting before the one I covered last Sunday, which, of course, Andrew alluded to during his 2 hour motion that he moved as part of house cleaning that Miller allowed him to do. So, as a result, that's why today they have changed the chair with Mr. Malone. So let's bring that up. And we have that sitting right here. And make sure we got our laptop eye. And, oh, I hope we have a microphone for this.
Ms. Dillon has been very disrespectful to our
No,
guests
I'm
by
not. You have been
suggesting
disrespectful.
that they
Your
are
whole
not
conservative
sophisticated enough
caucus
to
right here
understand
has
how
been very
parliamentary committees work. She's all.
Well, my hill to die on is freedom of expression. And this Liberal government has shown reckless disregard for that.
Just making things up as you go along.
I think the folks in the audience are very sophisticated people.
Yeah,
I
you were
think
sitting in
they
the back.
have
You don't
been in
know.
parliamentary
Yeah.
committees before.
That's
You were
enough.
sitting in the back.
Mr. Chair, you chastened me for speaking during her point of order. I
You still
suspect
kept
you will now
talking, though,
chasten
so me
her
too, I'm gonna do the
for
same thing now.
doing.
So that was just a recap, a very short recap. Some points of order that weren't points of order, followed by points of order that were points of order, pointing out that the point of order was not a point of order. All right, so let's get into this committee meeting, James Maloney. But just before we do that, if anybody was watching the earlier show of the NAP, where we're covering the question period, we ended off showing you with the aglio olio recipe that I put on my other gardening and cooking channel. And just to show you what we're going to be having for dinner, stuffing into our cake hole while we're watching this, I made myself another bowl of nice pasta with some freshly grated Parmesan on some olives there, and I didn't have any fresh basil, so I just used some dried basil. Made the pasta the exact same way as the other recipe. Of course, I've got some homemade zucchini and dill pickles. So both zucchini and cucumber pickles. And of course, I got some nice fresh bread that I baked this morning to sop up the rest of what's in the bowl. And let's get going with this committee meeting.
Told Mr. Lawton I will hear your point of order.
Yes, and I hope that the clerk can provide you a reference on how to acknowledge points of order, Chair. This was, as you acknowledged in your opening remarks, the resumption of the 13th meeting of this committee. We suspended at our last meeting, and that means that there was an item under consideration, which was a programming motion on this committee's work. I realized that we had to elect a new chair, and I congratulate you on winning that race. However, there is precedent if you consult the previous ruling in the Standing Committee on Foreign Affairs and International Development meeting of May 16th, 2022. The election of a chair does not constitute a substantive motion, and thus, after the chair is elected, the previous matters of business continue. So we are still, the dilatory motion that Mr. Housefather moved and we voted on was out of order. We are still on the programming motion introduced at the last meeting. There is precedent to this effect, pursuant to the rules of this committee, and under that, I would have the floor as I did when the meeting was resumed.
Thank you, Mr. Lawton. In fact, the ruling is that the debate on your motion was adjourned because of the resignation of the chair and the election of a new chair, which is why I opened the floor for motions. And
that is not what the precedent says.
I'm familiar with precedent, Mr. Lawton. You're free. I'll say this one last time. You are free to challenge my rulings, as is your right, but don't challenge my integrity.
I'm not challenging your integrity. I'm challenging your knowledge of the rules, but I will challenge the chair's ruling.
Okay. Well, you're free to do that.
Okay.
So not surprisingly, the chair is returnably antagonistic. Andrew kind of did start by saying, you know, maybe the clerk should point out how to do your job since you haven't been doing it for a while. But there was no need for the chair to point out what Andrew did not say. And as you can see, he's ramming this through. He's being a bully because he knows that with the Bloc Québécois on side to support going against religion and faith in his country by violating those charter rights, the deal that we know that the Bloc already has with the Liberals. I know that James knows this, so he knows that go ahead and challenge me. Yeah, challenge me, and I know I have enough votes that pass. That's what's going to happen here.
Point of order.
We're challenge the chair, Mr. Bauer, which we'll deal with that, and then we'll move on.
That the chair's decision be sustained, que la décision de la présidence soit maintenue. Mr. Chang.
Yes.
Madame Dillon.
Oui.
Madame Lantanzio.
Oui.
Mr. Housefather.
Yes.
No.
Ms. Cronus.
No.
Mr. Gill.
No.
Mr. Lawton,
No.
Monsieur Fortin.
Okay, ruling upheld. We'll move to clause by clause.
Point of order, Chair.
Mr. Janis.
Thank you, Chair.
I just want to say that the music that's in there, I didn't plan for that. I was using a different template, and I thought I had muted all the music, and I was in a hurry to render the file so we could do this live stream. But and of course, it won't be in there too long, as long as it doesn't get too loud and drown out the actual voices. It seems to fit, though.
Mr. Lawton mentioned a precedent, and I wanted to share that this is a precedent that actually involved me. It involved a chair that resigned as a member of Parliament, and it was in the middle of a meeting when a meeting was suspended. Mr. Spangeman was the chair at the time, and Mr. Assassi was elected to the chair. And my view previously had been that effectively the election of the chair led to the adjournment of the previous
Janis,
item.
I'm going to interrupt you. This is the same point of order.
No, Chair, it is.
No, Mr. Janis, just hear me out. I've ruled on it. An objection was noted. We voted on it, and it was upheld.
Okay.
So we're not going to hear the same point of order again. You're certainly not going to re-argue something that we've already decided.
Chair,
we're going to move to clause by clause.
It's a different point of order. Will you allow me to finish, Chair?
It's not a different point of order because you're
Chair,
arguing the same point Mr. Lawton just
you
did.
got a little bit hot when you thought people were challenging your integrity, and I'm not challenging your integrity yet, but I would encourage you to be fair to all members. And let me finish my point of order.
I'll give you a very short leash.
Thank you. I think the ruling was made by Mr. Assassi, who is still a member of Parliament, and the ruling specified, and I'm quoting directly from the minutes of the meeting. We certainly wouldn't want a situation where Liberal chairs made contradictory rulings in different meetings based on what they considered their partisan interest. The ruling by Mr. Assassi was, quote, the chair ruled, I'm reading from the minutes, so it said the chair ruled that the election of a chair does not constitute a new substantive question before the committee, and that therefore the committee remains seized with the motion and amendment previously under debate. This was the ruling of Mr. Assassi in exactly the same situation. So I want to just clarify, maybe the clerk can address the committee on this, about the role of precedent in the committee. Is this precedent relevant? Is it relevant that you have invented an approach that is completely opposite to what a Liberal chair did in exactly the same situation? I wonder if the clerk can address the relevance of precedent as a matter before the committee, which is, I think, a distinct issue.
I've just consulted with the clerk. This is exactly the same point of order.
Would you allow the
Mr.
clerk
Dennis.
to address the committee on the relevance of precedent,
Allow me
Chair?
to finish. This is the same point of order. It's already been ruled on.
No, it's not the same point of
It's
order.
already been challenged, and it's already been upheld.
So
My ruling is that this point of order is out of line.
What
because
is your
it's
ruling on the
redundant.
relevance of precedent, Chair? Does precedent
precedent.
matter?
No,
Because the
okay,
standing
we're
orders.
moving to clause by clause, Mr. Jennings. Thank you.
Can I cite the standing orders, Chair, which very clearly say that in unprovided for cases, it's in the standing orders. Will the clerk be allowed to address the committee?
All right, Mr. Jennings.
In unprovided
Mr.
for cases.
Mr. Jennings, I have ruled. You're now getting into the realm of debate, which is inappropriate because you've already been ruled inadmissible and out of line.
Point of order,
We're
Chair.
going to move on to Mr. Bobber's first.
Have you been a chair
amendment.
previously? I think you
Pursuant
have.
to Standing Order 75-1, consideration of Clause 1, short title is postponed.
Will you allow the clerk to speak?
The chair calls on new Clause 1.1. Mr. Bobber, I'll give you the floor.
Thank you, Chair. I'd like to begin that. I'd like to put that on the record. Mr. Housefather did not have the floor to move his amendment, but it seems as if the chair has decided, and any prosecution of process going forward is probably not a good use of our time. Chair, for the last 2 years, members of the North York community have been subjected to unprecedented events, including harassment, threats, interference with their enjoyment of property, and more. We fully understand that the events of October 7th have given much to think about and much to discuss and much to argue about politically and otherwise. But under no circumstances should the conflict in the Middle East spill onto Canada's streets. And regretfully, that's what we've been witnessing for the last 2 years. I think I'll formally move Amendment CPC 1, reference 13768-114. Several weeks ago, I've introduced a private member's bill, Bill 257, to amend the criminal code prescribing a new criminal offense, 83.171, being the willful promotion of terrorist activity, terrorist group, or the activities of a terrorist group. The first 4 amendments that are put before the committee today are all my amendments that essentially seek to incorporate Bill 257 into Bill C9. I'd now like to make an unusual request of a friend on the committee, namely Mr. Housefather, to waive privilege with respect to one of his amendments that he will introduce later today to enable us to have a full discussion.
I am fine to discuss Lib 2, which is similar to Mr. Baber's amendment, and to allow the justice officials to comment on the 2. I have no problem with that.
Thank you, Mr. Housefather. I hope that our Liberal friends will afford the same cooperation and spirit in which I bring these amendments. The original Bill C-51 that made it as part of the Harper government into the criminal code had already provided for some form of criminalizing the promotion of terror. Nonetheless, in 2017, the Justin Trudeau government repealed vast parts of Bill C-51, therefore creating a gap in Canada's criminal law legislation that effectively permits for the willful promotion of terror. Now, I think that quite often when we see this on Canada's streets, we confuse that for what is clearly incitement to violence. Members of this committee have previously heard me on record say that when someone chants "Viva Viva Intifada" or "Globalize the Intifada," in effect what they're doing is they're inciting to violence. However, it appears that law enforcement is reluctant to press such charges. However, we see terrorist headbands, we see flags. I note that on at least 2 occasions, charges were laid in the GTA with respect to flags, those of listed entities, and later those charges were stayed. And at the same time, we hear open encouragement on the streets at the University of Toronto, at McGill University, inviting students, residents to glorify terrorism and to glorify the events of October 7th. In my view, that is incompatible with Canadian society, and that should be incompatible with Canada's criminal laws. And that's why I'm proud to have introduced Bill 257 to criminalize the willful promotion of terrorism, and specifically the willful promotion of terror, terrorist activity, terrorist group, or the activity of a terrorist group. I have now, before Mr. Housefather interrupts me, I have been pleasantly surprised to learn that Liberal Amendment number 2, brought by my friend Anthony Housefather, seeks to do something similar, and that is to criminalize the willful promotion of terrorism or terrorist activity. And so I thank my friend for liking my idea and perhaps for sharing his own sentiment that willful promotion of terrorism should not be permitted on Canada's streets. I'd now like to turn to a technical discussion, and I'm grateful for the officials for being here, as my friend and I have some questions and concerns with respect to how such legislation should be advanced in Bill C-9, as it appears that both sides agree that it should proceed in one form or another. I have sought diligent advice from legislative drafters who drafted Bill 257, which was first read on November 17th. There are a number of key distinctions between Bill 257 and, which is essentially amendments CPC 1, CPC 2, CPC 3, CPC 4, and in fact, if the chair would permit me, I would effectively move all CPC 1, 2, 3, and 4 amendments together. I'm not sure if that is the right process. If it's the will of the committee, then I believe that we can do that.
We can do it. We'll have to vote separately, but I just want some clarification perhaps from Mr. Housefather without you ceding the floor, just on how that might affect the first amendment.
I think they're consequential one to the other.
Yeah.
CPC 1 to 4. So I personally have no issue that Mr. Baber moves all four because they all tie together.
Yeah.
And I think what he wants to do, Mr. Chair, is to have a discussion of the way he's constructed it versus how Lib 2 constructs it.
Okay, if you're comfortable with that, that's fine.
Thank you.
And then Ms. Latanzio has some questions, but we can.
And so, at least for the purposes of discussion, we now consider the first 4 CPC amendments moved. So, to the officials and to the committee to set the stage.
Once again, apologies. I seem to have a ghost introduction of a bit of audio there, music in the background, because I was using a template to hurry to render this file so we can do this live stream. So it should be over soon. And hopefully it's not too loud and doesn't drown out the voices, but it seems to fit.
When we look at Bill C-257 and we'll look at the amendments before the committee, the key amendment that does what I seek to do and what arguably Liberal Amendment number 2 seeks to do is contained in CPC Amendment number 2. And that's the Baber Amendment incorporating the key provisions of Bill 257 to create a new offense, the willful promotion of terrorist activity or a terrorist group, and changing the heading of the relevant section in the Criminal Code terrorist framework by including the word promoting at the outset of the heading. That specific amendment to the heading is contained in Section 2 of Bill 257. Do the officials have a copy of Bill 257? And so, I believe, Ms. Brees, are you the one vested with the expertise here?
Yes.
Okay. So if you look at Section 2 of Bill C-257, you will see that the bill imports the word promoting in front of the heading which begins the terrorist section. You're with me? Okay. So that's the key provision. That CPC 2 is effectively doing what we intend to do with the heading. CPC 1 is an ancillary or consequential provision of Bill 257, adding the new section, which is 83.171, to the definition of a terrorism offense in Section 2 of the Criminal Code. We know that Section 2 of the Criminal Code, like most federal statutes, is a section that prescribes the definitions used through the Act. And so CPC 1 amends the definition of the Criminal Code, specifically of the phrase terrorism offense, to include the newly created offense, 83.171. CPC 3 is also as ancillary consequential amendment, consequential to the main provisions of Bill 257, amending the definition of Section 183 of the Criminal Code by adding Section 83.171. That is another provision on the Criminal Code that deals with definitions, and specifically it codifies how investigations are run, but the intent of the section is not to prescribe anything new. I want to be very clear. We're not inventing anything new here. We're simply saying that given that we have a terrorist offense here, it should be treated like all other terrorist offenses under the Criminal Code. And specifically, this is the one that deals with sentencing. I'm not proposing that sentencing be reformed in any way. All I'm saying in CPC 3 and what Bill C-257 is saying, that just like all other offenses within Canada's terrorist framework are treated by consecutive sentencing, the new section will be treated in the same way. And so, again, I suggest that that is a necessary consequential amendment to the key operative amendment, which is really CPC 2. And finally, CPC 4 is also a Baber amendment, ancillary or consequential to 257, amending the definition of Section 183 of the Criminal Code by adding new Section 83.171, and that, I believe, is the one that deals with investigations of terrorist offenses. But again, I don't venture to redefine how Canada's security services investigate terrorism. All I'm saying is this is the framework. 83.171 is now a terrorist offense, and it therefore must be imported into the existing framework. I think that is basically it in terms of what I'm trying to do. Now, my friend, in Liberal Amendment number 2, amends C9 by amending the hate framework and specifically creates a subsections 2.4 and 2.5, adding to them, but again, does this within the hatred framework of the criminal code. I would also note that there are a few key differences between the section proposed by my friend, which can be found on page 12 of the package. I note that there is no page 11 subsequent to the amendments. And so New Liberal 2 does a couple of things. It amends the hate regime to include the willful promotion of terrorism, but with 3 key distinctions. Number 1, Bill 257 specifically omitted the phrase "other than in private conversations," whereas Mr. Housefather's amendment maintained that phrase. This is something that Bill 257 did deliberately. Because if we think about it, we're trying to criminalize the willful promotion of terrorism. What happens if it's a private conversation? One person approaches another person and tries to promote the activities of a listed entity. Just because it happens in a private conversation, in my view, respectfully, does not make it excusable or defensible, given the environment we're living in. I specifically distinguish this from the willful promotion of hatred because it's very much worth bearing in mind that to survive constitutional scrutiny, Bill 257 imports the framework of willful promotion of hatred, but and includes the same defenses to avoid some of the criticism we had on Bill C-51. I understand how private conversations involving hatred may be outside of the scope of the state, but I very much suggest that willful promotion of terrorism in private conversations should not be excluded from the purview of the state. The second difference and there's a bunch of them that I'm seeing, but at least those that jump out on me, is that Mr. Housefather's amendment prescribes the maximum penalty of 2 years for the offense that he's creating, whereas Bill 257 and specifically CPC 2 prescribes a maximum of 5 years. Now I suggest, regardless of the outcome, that we need to stick with 5 years because all the terrorism offenses prescribed in Section 83 of the Criminal Code prescribed a maximum punishable sentence of 5 years. And so to remain consistent, I propose that we stick with 5 years. And finally, in giving consideration as to how this should be drafted, Legislative Council was very mindful of the fact that Bill 257, or CPC 1 through CPC 4, needs to survive constitutional scrutiny, which is why CPC 2 tracks the language of willful promotion of hatred and prescribes for various defenses. Now, I understand that my bloc friend may have difficulty with one of such defenses. However, the balance of the defenses, I suggest respectfully, should be maintained. Whether it's the statements are true, or the statements were relevant to any subject matter of public interest, or in good faith, they were intended to point out the willful promotion of terrorism and for it to be removed. And so I am concerned that what my friend is proposing is weaker in terms of its ability to survive constitutional scrutiny. And finally, a fourth difference is that 257 and the CPC amendments prescribe that it's now criminal to willfully promote terrorist activity or terrorist group or the activity of a terrorist group, whereas the House Father Amendment, Liberal 2, only criminalizes the promotion of terrorist activities or the activities of a terrorist group. Perhaps by omission or by inadvertence, my friend does not criminalize the promotion of a terrorist group of its own, but just the activity of a terrorist group or terrorist activity, which I think is a oversight in his amendment. I apologize that I was lengthy, but I'm glad that everybody understands what we're facing here. We're going to dispose with a lot of amendments if we give this due consideration. The key question to the officials is, where are we doing this? Now, I suggest respectfully that we're dealing with a terrorism offense, and therefore we need to be doing this within the terrorist framework of the criminal code. Now, I understand that there are scope issues, but if we all intend to, and I don't concede the scope issues, because we're talking about terrorist symbols, we're talking about what's happening on the streets. This is what's happening on the streets in North York. However, my friend's amendment deals with the hate section that is otherwise already amended in this bill, that something I concede to. But just because my friend, Anthony Housefather, wishes to include this amendment in the hate section, doesn't make this a hate section. You can call a spade a club or a heart, but it's still a spade. It's still a terrorist offense. Thank you. Yes, sir. Yes, Chair.
I'm not going to stop you. We're going to suspend for a second. There's something going on I need to address. Non-committee related. I'll explain in a minute.
Thank you.
Okay?
Thank you.
So we'll suspend for a second.
Well, if you were following along, this is not as bad as I thought it was going to be so far. Again, we know that the Bloc Québécois still wanted to bring forward a motion to criminalize Bible verses along with the Liberals. So that might be one of the other Liberal amendments there. But right now, it seems that dealing with what Baber had in mind for his bill and how it affects Bill C9. You seem to be getting some traction there, and it's nice to actually see a committee actually trying to work together as opposed to all the BS that we have seen in committee so far. All right, I thought I had cut out all the dead time here, so let me see if I can make sure we move ahead here without losing too much. Oh, there we go.
Mr. Bauer, were you finished then?
Yeah, finished. Now that we have MP Dillon back with us, I wonder if I should repeat all of that. I'm just kidding. I'm glad you're feeling better, and I'm glad you're back with us.
Okay, thanks. Just, I'm going to go to Ms. Latanzio and then I think Mr. Housefather. But before you mentioned page 11. There is a page 11, but it's blank because there's no Lib 2 anymore. It's new Lib 2, which is page 12. So rather than renumber the whole packet, I think that's the explanation. So, okay, Ms. Latanzio, over to you.
I have a few questions for our officials here today. So I just wanted to have some clarification with regards to the terrorist definition and activity. So can you confirm to us whether the criminal code already encompasses and captures the counseling or promotion of terrorist activity under the existing terrorism counseling provisions?
Thank you for the question. So yes, maybe taking a step back, if I may.
Yes.
At the outset, so this motion, if I can share some observations, I can't provide legal advice. So if we look at the wording of the motion and the word promotes, I can say what the court has said promotes means. So promote means active support or instigation. It is more than simple encouragement or advancement. And then the courts have said what counseling is. So deliberate encouragement or active inducement of the commission of an offense. So I guess the committee would have to consider whether, in fact, we are creating through this motion a new terrorism counseling offense. So step one. The criminal code already has counseling offenses. So we have the one specific to terrorism is at 83.221, and that's the offense of counseling the commission of a terrorism offense.
Okay.
And so against that backdrop, this motion, if it is considered, if the committee considers it to be more of a counseling offense, then the committee might want to consider whether it aligns or not with existing counseling offense, and maybe I could share a few observations on that. With respect, for example, for the mental fault requirement, the committee might want to consider here the motion's proposing willful, which means intentional. Other counseling offenses in the code, it's recklessness. And recklessness is the person is aware that there's a danger or risk in their conduct and that could result in the crime in question, and they nevertheless take the chance. The committee may also wish to consider the penalties. So the existing terrorism counseling offense, I believe, is a max 5 years imprisonment. So that would align with what the motion is proposing. And in terms of defenses, so again, this motion is proposing merging two existing offenses, a willful promotion offense and a counseling terrorism offense. It's actually 83.83. It's participating in a terrorist, an activity of a terrorist group. So the committee may want to consider whether importing hate propaganda, hate speech defenses are a right fit with a terrorism counseling offense. For example, is the intent to shield someone from criminal liability who counsels a terrorist activity if the statement is true? So those are general observations just on some of the points the committee may wish to consider.
Thank you. So with regards to the new terrorism promotion offense in the definition of terrorism, would, in your opinion, that create inconsistencies with the existing terrorism framework that we find in Part 2.1? Do you see any inconsistencies there?
Okay, in the code. So again, I can't provide legal advice. What I can say is the motion is proposing a different mens rea than what is currently in 83.221. That can be a policy decision for the committee to discuss. If you look at the terrorism provisions, there's no defense akin to what is being proposed. Those defenses model the hate propaganda defenses. So the committee may wish to consider whether that's the right fit, because this is what is being proposed is not a hate speech offense, it's a counseling, more akin to a terrorism counseling offense.
Speaking of the willfulness and the mens rea, so do you see any charter risks with regards to introducing a higher degree of proving the willfulness of the mens rea than the existing terrorism counseling offenses that rely on, let's say, recklessness?
question. Unfortunately, I cannot provide legal advice, including charter advice.
This type of change require consultations with national security partners, given that it rewrites the terrorism scheme.
Hi, Chair, may I? Yeah.
Please go ahead.
Thanks so much. So the proposal is actually, there are various elements, and you heard my colleague sort of take you through some of the elements. There would be charter considerations because of the change in the mens rea. There are elements of the terrorist counseling offense, as my colleague explained, sort of merged into this proposed offense, which is closer to a counseling offense. And I would say that what the committee might wish to consider are, in addition to the mental element, the mens rea, in addition to the potential charter risks, in addition to duplication and perhaps some overlap, would also be consistency and coherence with the existing provisions. So there may be unintended consequences that we can't really necessarily speak to all the specifics right here in this answer off the top, but it would require, an analysis and assessment and further consideration to ensure the coherence and the consistency, and to perhaps dig down into what the implications would be in the criminal code.
Okay, and one last question, if I may, Mr. Chair. So would this amendment be within the scope of the proposed bill addressing and tackling the hate crime reforms?
In answering this question, I'm sort of mindful of, my role here at the committee. I would say that is perhaps a question that might be best dealt with. In terms of an opinion, I can't provide an opinion really on what's on scope really. Certainly 83 what I can say is that the counseling element is the terrorism counseling offense essentially is what we talked about. It's not included as any of the clauses in the bill.
So would you say, my last question, would you say that this extends the scope, this amendment would extend the scope and the definition that we have in the proposed hate bill crime?
So it's a different part of the code, essentially. There's no proposal in Bill C9 to amend the terrorism provisions in the code.
Mr. Housefather.
Thank you, Mr. President. So first of all, I want to thank my friend Mr. Weber for these amendments, because I share his desire for a criminal code clause to include the willful promotion of terrorist activities, or to promote the activities of a terrorist group. I share his view that this should be in the criminal code. I share his view that it should be a specific offense. And I appreciate his leadership in putting forward a private member's bill on this subject. But I think we all, on both sides of the aisle, who care about having this as an offense, want to put it in C9, a government bill, to ensure it becomes law even more quickly, and then give Mr. Weber due credit, and then allow him to put forward a different private member's bill if needed. The goal is to make this law, right? I think we should agree on that. I think where we differ is there's just a couple of issues as to how I would consider the two major issues. One, we don't want any amendment that this committee may pass to be struck down by the Speaker as being outside the scope of the bill. And by using clauses that are outside what the bill originally intended to do, it makes the danger of that, to me, much greater, which is why I totally understand why my colleague is rightfully saying this is a terrorist offense. It should go in the terrorist section of the bill, but the terrorist section of the bill was not, there was no terrorist section of the bill. And adding this as a clause in that section, to me, creates a risk that regardless of how this committee votes, the Speaker today struck down amendments from a different committee. I would rather see it in the sections of the bill that we're actually amending, or so the sections of the Act that we're actually amending to remove or mitigate that risk. The other question we both have, I'm sure we all agree, is we want this to be upheld constitutionally. And I think that there's two differences in how we treated the issue. One is the communicating statements incorporating private conversations in CPC2 and Lib 2 not incorporating private conversations. I think incorporating private conversations for me creates a charter risk. I don't know if you folks would want to opine on the potential charter risk of incorporating private statements, but at least in my view it does. I'll let you come back and let me know if you have a position on it or not, or if you're allowed to speak on it. I don't know if you are or not, because if that's legal advice, I understand you can't, but if you can't, okay, understood. Just that's how I would take it. The other thing is, both of us, and by the way, let me give due credit to Mark Sandler, who I know worked with Mr. Baber, who worked with me, who has been a leading voice in this fight against hate in Canada, along with members of an alliance that are all doing exemplary work. I was originally going to do what Mr. Baber did, which is incorporate the same hate defenses in what is essentially a terrorism provision, because that's what was suggested. But I don't believe, in the same way that Mr. Baber said, private statements, well, a private statement, he feels strongly that it should still be an offense. I feel strongly that the defenses that are listed as hate defenses aren't terrorist defenses. Regardless of someone who, for a religious basis, thought that it was okay, I don't think you're allowed to commit a terrorist act because you have a religious good faith basis for it. So I think we've drafted it a bit differently. I think we could choose to amend one or the other to try to make it more, look at it. But what I am definitely concerned about is the way CPC 1 to 4 is that it's in a section of the Act that doesn't come into the bill originally, and I'm afraid it would be thrown out. And as a result, I with great respect to my colleague, who I, again, truly respect and give him due credit, whichever version passes, I believe that it is better to go with the version where we're taking clauses that are already in the bill. So that's my thought, and I'll leave it there. And again, I appreciate the collegiality on this discussion.
Okay, back to you, Mr. Bauer. Can I just comment? I'm so pleased to see how well everybody's getting along right now.
Thank you, Chair. My colleagues' comments are noted and appreciated. Perhaps if I may substitute my humble view for the officials for the benefit of Ms. Latanzio, at least in my view. Counseling a terrorism offense is already in the criminal code. Promoting is not. Promoting does not come to the level of counseling. We clearly see a gap. With respect to the willful element and the mens rea, we're talking about speech. I am open to Mr. Housefather's suggestion that we don't need to go there. At the same time, I would hate it if this provision was struck down, a block west from here. And finally, with respect to the scope, I would say, look, you got to look at the spirit of the bill, right? You're talking about not just hatred, you're talking about terrorism, terrorist symbols within a hate speech section of the criminal code. I would think that this were a word by extension. However, in the interest of saving the committee time, I would think, Chair, that it would be advisable if we briefly suspended to allow for a conversation between myself and my friend. Thank you.
Okay, suspend.
We've had some discussions with my friend, Mr. Housefather. I understand that my friends on the other side of the aisle are going to do some thinking, which is why at this time I'm going to move to pause. It's to park the debate on CPC 1 through CPC 4, and I therefore move to stand down consideration of Clause 1.1 and Clause 2.
Are we having a vote on it? Okay, yeah, okay. All right, we're going to vote on it.
Madame Latanzio,
I'm not in favor. No.
No.
Ms. Jasek,
No.
Mr. Chang,
No.
Mr. Baber, sorry.
Yes?
Ms. Cronus,
Yes.
Mr. Gill,
Yes.
Mr. Lawton,
Yes.
Monsieur Fortin.
Oui.
So now we go for C. Okay, so that takes us then to CPC 5, Clause 3.
I just understand when you stand it down like that, does it mean we would go through every other one of the amendments and then come back to it at the end?
My understanding, and I stand to be corrected, is that we're just postponing the debate and the vote on those proposed amendments.
But it would be the last thing we
They
do
would
after
do
the
that
other amendments.
before we adopt the title
Okay.
and the bill and whatnot, yeah. You're changing the order of the... Okay, so we'll now move to CPC 5, which is also Mr. Bauer. Clause 3.
Well, since we're doing so well, why stop now? Could we entertain a very quick suspension and maybe confer with my friends on the other side and with the block to, because, yeah, if I may, we have 3 or 4 similar amendments on the floor before the committee. Specifically, we have a variation of dealing with the business of removal of the consent of the Attorney General to the commencement of hate-related prosecutions. CPC 5, the Baber Amendment, proposes that you cannot lay a hate speech offense, essentially, by private prosecution within the framework of 504 without the consent of the Attorney General. Now, I went through the amendments very carefully, and I have been able to identify all of the amendments that deal with Attorney General consent, whether it's to all public-related prosecutions, hate speech prosecutions, or just by private prosecutions, and I have identified them to be CPC 5. Sorry, do I have... I need to ask for privilege to waive privilege of amendments that have not been introduced yet. CFO Tan? It's okay with you? And Ms. Latanzio, is it okay with you if I speak to your amendments that propose to deal with that, just so we lump them all together?
You can.
Thank you. So, Chair, my understanding is that we're dealing with CPC 5, Block 1, CPC 8, Liberal 3, Block 4, and CPC 11. There is various proposals on the floor, but I believe that if we take a quick break, we'll be able to arrive at a fairly quick resolution.
Okay. We'll suspend again.
Hey, well, looks like the Conservatives won their last motion. I'm not sure what was in there, but given how the Conservatives have been trying to preserve free speech and not let Bill C9 go ahead and squash the pass is going to help. Now, of course, I heard them talking now. They're talking about the most important part of this bill, which would have given the ability for you to be arrested without warrant by local coppers, however they feel about it. So let's see what happens.
Mr. Bauer.
So I'm hereby advised that the CPC will withdraw CPC 5, CPC 8, and CPC 11.
This is just to advise the committee members that we're going to be pulling back on Lib 3. Lib 3,
Just to confirm, is that new Lib 3?
new Lib 3, sorry. That's why you didn't have it.
You're withdrawing new Lib 3.
Lib 3, the new Lib 3.
Okay, all right.
Because we were trying to follow your thing and it was the new one.
No, there's no new Lib 3. There's only one.
The one that deals,
Lib 3 is about the Attorney General.
Attorney
and
General.
making a distinction between private and public prosecutions.
let's make sure that you have the right one. The theme here is the AG consent. Yes. Well, there's only one.
There was never new Lib 3. It was always the same Lib 3.
Anyways,
But it's
it's
withdrawn.
I have the other copy.
Oh, Mr. Chair? Oh, I think, again, I think if, again, with the indulgence as Mr. Beer has before, I think there you have an agreement amongst the committee to move to the Attorney General related amendments, all of them before we go to the next thing that's not an Attorney General related amendment. I think there's BQ1 and BQ4, bloc 1 et bloc 4, dont moi je proposerais, Monsieur le Président, qu'on peut...
I would move, Mr. Chairman, that we do Block 1 and Block 4 before we move to the other amendments.
The BQ, yeah.
Yeah, basically that we do BQ1 and BQ4. We've removed the other Attorney General related ones, so we finish with the issue of Attorney General consent before we move to other amendments.
Okay, when you say we're going to do them, I mean, let's use precise
We
language.
treat them BQ1, then BQ4 before going back to the next one in order of sequence.
Okay, all right.
Mr. Chair, we just want to deal by themes. So this would be specifically on the AG consent, the
No,
amendments
I
on AG
understand. It's just
consent.
we've been doing a lot of things. I want to
Yeah.
make sure I've got the word "do"
Okay.
defined properly in this
Okay.
context, that's all. Mr. Bauer.
If I may also, I thought I heard the legislative clerk say that there is no new Liberal 3. There is new Liberal 3 by Mr. Housefather. It ends with 153. So that's the Lib 3 that I believe my friend pulled. Thanks.
The committee can vote on
Okay. There's some dead air here while they keep their mics off. Try to
Okay, I'm
Uniform
told we can
foxtrot
vote on
themselves?
BQ1, but we can't vote on BQ4 because there's a line conflict with the NDP amendment, proposed amendment, which in sequence comes first, so. I don't know if that changes anything from,
On peut disposer du NPD aussi, là.
We could deal with the NDP amendment as well, so we can move forward.
Yeah.
Alors, Monsieur le Président, je propose...
So, Mr. Chairman, thank you, Mr. Chairman. I move that we pass BQ1.
that's my kind of submission, just for the record. Okay, we can do this by show of hands, or we can have a recorded vote. Show of hands. All in favor? Okay, she's not a voting member.
No, she doesn't.
No, no.
Sorry. She
Yeah.
doesn't.
Okay, so, no.
Yeah.
Okay, so amendment passed.
Carried.
Thank you, carried.
Lost 3.
well, what was that amendment? This is the Bloc Québécois Amendment 1. I hope that wasn't the amendment. to criminalize Bible verses as being hate speech. Oh, I guess we'll see.
As amended by BQ1.
Okay, so now we're voting on Clause 3 as amended by BQ1. All in favor? Carried. Okay. So now we'll go to Clause 4. We'll go to NDP 1. Is that my understanding? Okay.
Yes.
Okay.
Read this here.
Read this here. Okay. NDP 1 is deemed moved pursuant to the routine motion adopted by the committee on June 17, 2025.
And give the floor.
And I'll give the floor to you, Ms. Hidlow.
Thank you, Chair. NDP 1 is an amendment that I've consulted with civil liberties associations here in Canada. If approved, it would remove the portion of the bill dealing with symbols. This portion of the bill is problematic for some reasons. For example, it requires a defense for not being aware of the association with the symbol. Secondly, the words, quote, principally used, end quote, by, or quote, principally associated with, is a problem because we don't know who needs to be having that association. The association of symbols can vary from community to community, and the best example of that is the kafia, the traditional scarf worn by Palestinians. And thirdly, for the third reason, the portion of this bill is problematic is that it relies on the terrorist list, which allows for potential political misuse by future governments. To conclude, I would like just to share very quickly that organizations who've expressed concerns about the symbols portion of this bill include Canadian Civil Liberties Association, International Civil Liberties Monitoring Group, National Council of Canadian Muslims, Independent Jewish Voices, and EGAL. And just while I have the seat, I wanted to share very quickly that because this bill was expedited the way that it was quite difficult to make sure that we hear from as many people as possible. I've heard a lot of opposition to this bill. Preferably, it would be a bill that we can't support, but the only way to ensure that the NDP voice is heard and that NDP amplify the voices of these organizations was to submit this amendment. Thank you.
Wow. That's testament to the social media campaign I think that we've all been involved in getting people to call your MP about Bill C9 to express you being against it for what it's trying to do, especially the fact that, the Liberals let our whole justice system go to crap, and they did it on purpose by repealing laws, by introducing their own legislation so they could do this. I'm glad that she said that. I'm glad that she mentioned that she got a lot of calls and said don't support the bill. And then she explained why she did her amendment. That's brilliant.
Thank you, Ms. Hidlow. I don't know if there's any other speakers on this, but I'll read this now.
Yeah.
Okay, I should let the table know, let the entire table know, if NDP 1 is adopted, BQ2, Lib 1, CPC 6, CPC 7, New Lib 2, BQ 3, and CPC 8 cannot be moved due to a line conflict, and BQ 4 cannot be moved due to incoherence. Okay, just letting you know. All right, is there any other further discussion on this proposed amendment? Seeing none, okay. We'll vote.
find it fascinating that the amendment that the NDP put forward is complete common sense, makes complete sense what she put forward, and I find it fascinating that it conflicts with amendments brought forward by the CBC. I'm not surprised that it conflicts with liberal amendments or Bloc Québécois amendments, right? Because they're pretty far left themselves if you listen to their politics. All right, we're almost to the end here.
2-3 minutes.
Okay.
Can you just repeat the ones, can you just repeat them one more time?
Yeah,
Yeah.
I'll read that again.
Yeah.
If NDP 1 is adopted, BQ 2, Lib 1, CPC 6, CPC 7, new Lib 2, BQ 3, and CPC 8 cannot be moved due to a line conflict, and BQ 4 cannot be moved due to incoherence. That's fine? That's fine? Okay, so we can put this to a vote now?
Yeah.
Can we do a show of hands? All in favor?
We're calling the vote.
Calling the vote. All in favor? Opposed? Abstentions? Okay, all right. Not carried. Yeah, okay, defeated. Thank you.
And I
Mr.
now
House
propose
Father?
we move, as I think that everybody had agreed, to BQ4, so that we can deal with BQ4 maintenant.
To BQ, sure? Okay, BQ 4. Okay, so that's done. Where's BQ 4?
Q4 is. It's just.
Okay. Mr. Fortin?
Monsieur le Président, merci.
Mr. Chairman, I move that BQ4 be adopted.
Thank you. Any other comments? No? Okay, all in favor of BQ4? Carried. Thank you. Ms. Latanzio?
I motion to adjourn.
Okay. We need to vote on that.
It's dilatory, so
Yeah.
you can show of hands or.
Show of hands, all in favor of adjourning.
Suspend for a moment, Mr. Chair. Monsieur le Président.
It's a dilatory motion. I can't suspend when the motion's on the table.
Speak with them, eh, about that? No? Did you?
They got resources to midnight, so we're voting no.
I understand. Patricia, t'as pas parlé avec...
Okay? That's a vote, yes? Okay, all right. Meeting adjourned.
Well, so more to follow. It'll be nice to know what these amendments are. But as we can see from the posts that Andrew Lawton has been putting out and the other members of the Conservative Party, they're all over this like stink on poo to ensure that our freedom of expression is protected. Again, Andrew has worked on this for quite a while, back from being initially his journalism onto his radio show, and then the website that he had briefly called Landmark Report that I wrote for also, and then he moved on to doing more radio, and then True North, and then Juno News, published a couple of books, and then decided to join the Conservative Party and ran a successful campaign, and is now a member of Parliament. I'm very proud of him. Well, just keep looking out for his post, and he'll keep you up to date on this. And I guess we will just be looking out for the next committee meeting to see when that is going to happen, and to ensure that our freedom of expression does not vanish, at least without some form of independent overview. And I will not be the only creator online covering this. All right, we'll finish off with this closeout as part of the file, and we will see you tomorrow morning. Or tomorrow morning. Yeah, tomorrow morning. Before the nap. It's not tomorrow morning. The nap's at 1:30, 45 minutes prior. Tomorrow afternoon. Yes. The nap, 1:30. See you then. Bye-bye.
Okay.